Hello, James, and members of the panel and audience at IIFT. Thank you for affording me the opportunity to present my ideas with you virtually through this video recording. As agreed with James, I'm presenting the argument set forth in my recent article with Sergio Puig, Imperfect Alternatives, Institutional Choice, and the Reform of Investment Law. It was published in the American Journal of International Law this year. It is also available on SSRN, where you can read and download it. The article applies the theory of comparative institutional analysis to evaluate trade-offs which are associated with alternative mechanisms for resolving investment disputes. We assess the trade-offs in light of the principle of accountability under the rule of law, which underpins the goals of fairness, efficiency, and peace that are attributed to investment law. The article makes two recommendations. First, reform should address complementarity between domestic and international institutions. Second, institutional choices should respond to the different contexts that states face. The tide is turning. Ferment is in the air. Reform or even transformation of foreign direct investment governance appears on the way. Different proposals are advanced, different proposals trashed. Some defend the current arbitral system of investor-state dispute settlement. Others support the alternative of a multilateral investment court system. Some focus on market mechanisms, others on national sovereignty. What we lack is a framework for comparatively assessing the range of institutional alternatives in light of their relative trade-offs. Our article provides such a framework. Our central claim is that all institutional alternatives are highly imperfect because of the dynamics of participation within them, and thus criticism of one institutional alternative without comparatively assessing the imperfections of real-life alternatives is of little help and can make for bad public policy. To assess trade-offs, one should address two issues in parallel: goal choice and institutional choice. First, goal choice. We assess three different goals under the ISDS system and then place them within the framework of the rule of law. A first commonly expressed goal of the ISDS system is fairness. ISDS, it is contended, provides access to justice for aggrieved investors claiming unfair treatment. It is commonly argued that the investor faces what law and economics scholars refer to a time inconsistency or hold-up problem. In essence, the investor may have bargaining power when it makes the investment, but that bargaining power diminishes after it invests capital that it cannot easily and quickly withdraw when conditions deteriorate. In our view, however, focusing on fairness with a single vision of as it affects foreign investors builds from a number of flawed assumptions and can create a structural tilt against state regulation in the interests of other stakeholders represented by the state. First, the one-sided focus is based on an assumption that overstates the relative position of the state in relation to investors, which are often large, powerful corporations from comparatively rich nations that have many options to protect themselves. Second, a one-sided focus on fairness obscures the fact that foreign investors may be in a much stronger position than other stakeholders in relation to the host state through their ability to lobby, bargain contractually, obtain insurance, and harness home state diplomacy. Third, a one-sided view on fairness presumes domestic courts cannot be trusted. Yet if this is the case, then domestic stakeholders can be prejudiced as well, but they have no access to a specialized forum to sue foreign investors. An asymmetric focus on fairness in the definition and interpretation of foreign investment law, in short, is unfair. A second goal of ISDS is to promote resource allocation efficiency through reducing the state's cost of capital and thus increasing national welfare and supporting economic development. But from a law and economics perspective, resource allocation efficiency involves the optimality of investment protection and not investment promotion per se. Otherwise, ISDS will have an anti-regulatory bent, since the best way to attract investment would be to limit government regulation. Absolute investment protection is not optimal and thus not efficient because it precludes the balancing of other social welfare goals. A third normative goal of investment dispute settlement is to reduce interstate conflict and thus support peaceful and cooperative international relations. From this perspective, the adjudication of disputes involving foreign investors helps ensure that investment disputes are resolved by law instead of coercion. Many, such as Martins at a conference, question the continued usefulness of discussing the depoliticization in the contemporary context. We add to the debate that the conventional conception of ISDS in terms of depoliticization once more has had a rather one-sided pro-investor focus. It promotes ISDS to advance this end. However, the goal of international cooperation, while it is indeed an important one, should be viewed equally in terms of reducing constraints on states' ability to adapt regulation to changing contexts in light of experience and new information. It's thus a question of institutional design. We contend that the three conventional goals of investment protection reflected in ISDS, fairness, efficiency, and peace, are linked both analytically and consequentially to a broader principle, accountability under the rule of law. The article explains how. Briefly stated, for us, the rule of law is best conceptualized from a socio-legal perspective that focuses on goals and practices. The goal of the rule of law is to create restraints on government in order to provide security and predictability so that individuals and firms can plan their pursuits and do so without fear. Its basic conception is opposition to the arbitrary exercise of power. Ultimately, however, for the rule of law to become effective, it must be institutionalized as part of a culture of practice, of appropriate conduct. From a socio-legal perspective, the rule of law provides restraints on arbitrary state behavior backed by norms that enable people to reasonably know what is required of them. One of the disconnects in the field of the ISDS is that proponents focus on the need for investment arbitration because of challenges with the domestic rule of law, while opponents focus on the failure of ISDS to adhere to rule of law standards. Yet both of these mechanisms are subject to severe imperfections. Thus, any meaningful choice between them from a rule of law perspective must engage with a comparison of their trade-offs, along with those of other institutional alternatives. This brings us to part 3 of the article on comparative institutional analysis. However one frames, and that is the core of the article. However one frames the goals of investment law, those goals must be pursued through institutional mechanisms involving interested actors in different decision-making processes. Thus, goal choice must be complemented by institutional analysis, whatever the goal may be. For institutional analysis, the key question is, compared to what? A realistic assessment of the possible approaches for resolving investment disputes should take account of 3 central points. First, the pursuit of any normative goal is mediated by social decision-making processes. Second, these decision-making processes are biased, all of them, in different ways because of the dynamics of participation within them. Third, any meaningful public policy analysis must involve comparative institutional analysis of real-world rather than ideal alternatives. The key is to assess institutional alternatives comparatively. To do so, one looks at such factors as numbers, complexity, and per capita stakes, that shape the dynamics of participation. One then assesses the implication of these participatory dynamics on different forms of bias in institutional decision-making. Part 4 applies this framework to a range of market, political, and judicial options for resolving investment disputes. We stress that an analysis of institutional alternatives for handling unfair treatment, discrimination, and expropriation of foreign direct investment should include not only the range of plausible adjudicatory options, but also non-adjudicatory mechanisms. The article goes into detail applying the comparative institutional analytic framework to assess 6 types of such options. First, market mechanisms. We look at reputation, contract, and insurance. Second, political mechanisms. Here we look at negotiation and mediation mechanisms. Third, domestic dispute settlement mechanisms, including courts, specialized processes, and ombudsman offices. Fourth, we turn to independent interstate adjudicatory mechanisms, whether ad hoc tribunals or permanent international courts. Fifth, we look at international adjudicatory mechanisms that operate as substitutes for domestic adjudication, such as ISDS and the proposed multilateral international court system, which is being discussed in UNCITRAL, among other options. 6, we look at international adjudicatory mechanisms that operate as complements of domestic adjudication instead of substitutes. Here we address 3 options, as well as a range of others to which we point. First, international review of domestic decisions, which you see in NAFTA Chapter 19, where a binational panel reviews a domestic agency determination. Second, international claims after domestic proceedings have been completed, such as disputes involving property rights before the International Court of Human Rights. And third, interpretation by international court at the request of national courts, which you see as a model in the European Union. Note that India's model bilateral investment treaty is an example of this 6th category, since while it incorporates ISDS, it conditions its use on the initial pursuit of remedies before domestic courts for at least 5 years. In this long section of the article, we explain the trade-offs of each of these institutional alternatives in relation to the goals of investment law on the one hand, in light of biases of participation in decision-making on the other. We conclude our article with 2 recommendations. First, policymakers and scholars should pay greater heed to the place of institutional complementarity in support of the rule of law in domestic jurisdictions as a central consideration of the international investment regime. The argument for complementarity is that where possible, international processes should be structured not as substitutes, but as complements to domestic processes to assure government accountability. Note that this is reflected in India's model BIT. Second, we contend that policies and scholars should recognize that countries face a range of contexts in terms of capital endowment, market size, ideology, institutional development, and historical legacy, and that these contexts will affect their institutional choice. We thus conclude calling for flexibility and pluralism, as flexibility permits states facing different challenges to select from a menu of imperfect institutional alternatives in light of their trade-offs. The article provides them with a framework for making such choices. Thank you for your time and consideration of these ideas.